Hey everyone, welcome to another episode of Darshan Talk. My name is Darshan Kulkarni. This interview is brought to you by the Kulkarni Law Firm. I'm really excited to have with us our guest today, who is a lawyer at Alice G. Gosfield and Associates PC. It's a high-end nano law firm in Philadelphia. She works and represents physicians, their groups, and people who want to do things with them. She is the past president of the Health Lawyers, past chairman of the board of NCQA, and we're delighted to have her. I landed up reaching out to Alice, asking her if she'd be open to coming on. I originally wanted to talk a little bit about Stark and have some conversations about that. And she was like, no, we can't start from there because people misunderstand what Stark is and that Stark isn't what people think it is. So I was excited about the topic because it explains it explains some of the fundamentals that, quite honestly, a lot of us get wrong. If I do want to clarify that if you get a chance, you should visit www.gosfield.com, which is on your website on the screen right now. Or if you want to contact Alice, you can reach out to agosfield@gosfield.com. So I'm really excited to have you. Hey, Alice, pleasure to meet you.
Pleasure to meet you. Thanks for inviting me. Thanks
for coming on. So let's start with the beginning. We were going to talk about Stark and anti-kickback, and you were vehement that that's not the right place to start, that Stark is not the focus. So talk to me a little bit about why this is something you're so passionate about.
So I hear many people say kind of offhandedly, oh, I think they've got a Stark problem. Stark is a relatively narrow law. I'll describe what it prohibits in a minute. But people are, in this day and age, in 2022, ignoring the far broader, far deeper reach of the Anti-Kickback Statute. So let's start with Stark. The Stark statute originally was enacted to prohibit referrals by physicians only to clinical laboratories where they had a financial relationship, and only under Medicare and Medicaid. I'll get back to the Medicaid provision in a minute. I have said repeatedly that the Stark statute is the single worst piece of legislation I've had anything to do with in my career. I say it so often that I have clients that have created a drinking game associated with this, that every time I say it, they take a chug of their libation of choice. My standard line is the people who wrote it were not unduly burdened by any knowledge of the way Medicare actually works. So they use terms that are technical terms in Medicare interchangeably. They don't understand the significance, and the regulations that have had to interpret this terrible statute have struggled with this. So the first thing is the Stark statute pertains only to physicians as they are defined in Medicare, which is MDs, DOs, podiatrists, chiropractors for the one service that Medicare pays for, which is the manipulation of a subluxated spine demonstrated on an X-ray that they will not pay for if the chiropractor orders it. So it's literally one service. Dentists and optometrists are all included as physicians. So it's the broad definition of physicians, but it's not physician substitutes or physician extenders. So even if you have PAs, CRNAs, NPs that are doing exactly the same thing physicians do, the Stark statute has nothing to do with that. It is a Medicare-only statute. It also, part of their lack of understanding of the way healthcare works, the staffers wrote a provision that is completely incapable of being implemented that says that no federal financial participation will be made available to a state under the Medicaid program, which is funded part by states in the multi-millions of dollars, part by the federal government in multi-millions of dollars, for any single service that would be denied as non-covered under the Stark statute if it were under Medicare. There's no way that you can go to the federal financial participation that a state gets and find $150 for a violating CT scan that somebody got under Medicaid. That said, there are whistleblowers who have brought cases under Medicaid, and courts have allowed them to proceed, even though we don't have follow-up that says what has subsequently happened. So it's a physician-only statute. It's a Medicare-only statute, and it says it is prohibited for a physician or an immediate family member of a physician to refer a Medicare patient to an entity for the performance, and there is a hit list of designated health services. It includes inpatient, outpatient hospital services, home health agencies, not skilled nursing facilities, not kidney dialysis. It includes durable medical equipment. It includes outpatient prescription drugs. It includes all imaging, MRI, CT, PET, and a plain film chest X-ray, ultrasound, but it doesn't include all diagnostics. So EKGs, EMGs, EEGs, none of them is considered a designated health service. So it's physician-only referral, Medicare-only payment, referral for designated health services only, and then you cannot make such referral if the physician has or family member has a financial relationship with the entity, unless it meets one of, depending on how you count, about 17, 20 exceptions. Unlike the Anti-Kickback Statute, which I'll get to in a minute, the Stark statute is a strict liability statute. You either fall within an exception or you violate. Your intentions can be as pure as the driven snow, and it matters not one iota if you don't fit within an exception. So that, again, is decidedly different. It is a civil penalty statute only. It is $15,000 fine for each improper claim that is submitted for a violative service. It's $100,000 civil money penalty for a circumvention scheme. However, as a result of the Federal Enforcement and Fraud Enforcement and Recovery Act, that provided that if a physician practice that would be submitting a claim, or a hospital that would be submitting a claim pursuant to Stark, does not repay voluntarily monies that become available to them pursuant to violating transactions, that they convert into false claims, which makes them available to whistleblowers. And false claims are, you should imagine the cash register ringing ka-ching, 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 because it's at least $11,000 per item on the claim form, plus triple the charges, which is why when you see settlements under this, they're in the multi-million-dollar categories. So that's sort of the boundaries of what Stark is. Now let's turn to anti-kickback.
Could I ask a question about Stark before you go to anti-kickback? One of the things I've read, again, just to clarify, I'm not a Stark person, obviously, as you'll tell from this question, but I know that there's Stark 1 and 2, and I think there's a 3. What's going on with that? Why are there so many Starks?
They're all the same. So what happened was that Stark 1 was the rudimentary version of Stark that prohibited only referrals to clinical laboratory. Stark 2 was then when they amended the statute to add the whole hit list of many more designated health services. Stark 3 is really not referred to as the statute Stark 3 with changes, but is more relevant to the iterations of regulations. There were no regulations published for, I think it was almost 6 years after the statute was enacted. And now what they do is, instead of publishing separate Stark specific regulations, they include modifications, and have multiple times included modifications when they publish the physician fee schedule or when they publish the prospective payment schedule for hospitals. So finding where the regulations are is difficult enough. And Stark 3 was the 2007 regulatory iteration. The most recent regulations that have addressed Stark were published in December of 2020. And because Stark reaches directly into the internal operations of physician group practices, they held off on the implementation or enforcement date for those 2020 regulations until January 1, 2022. And then in 2022, they published a correction of something that they had done in the 2020 regulations, where they inadvertently, they said, forgot to address a fairly convoluted technical issue that I won't bore anyone with here. But the regulatory context in which Stark is implemented is horrifying.
Okay, so So basically, it's all the same statute. It's just done in different versions, and that's what it comes down to. Okay. And then you were going to go into anti-kickback.
Yes. So the anti-kickback statute is far broader. Now, I'm not reading this. I can do this drunk and I can do this in the middle of the night. The anti-kickback statute says it is prohibited to solicit, pay, offer, or receive any remuneration in cash or in kind, covertly or overtly, directly or indirectly, including kickback, bribe, or rebate for the referral of a federal patient to induce the referral, or, and many people forget this part of it, for ordering, providing, leasing, furnishing, recommending, or arranging for the provision of any service, item, or good payable by a federal healthcare program. That is way broader than Medicare and Medicaid. It's Title 20, it's Title 5, and interestingly, the government has never published a list of what they consider to be included under the rubric of federal healthcare programs. So lawyers like us have developed our own list, and we have a list of about 20 federal payment programs that are implicated under the anti-kickback statute. The other thing that's important that you can hear in the breadth of the impact of the anti-kickback statute, it's what I call the sun, the moon, and the stars statute, because it includes everything, and it includes everybody on the food chain of the transaction. So there was a period of time when there was case law that said that you couldn't be dinged under the anti-kickback statute unless you were the person who submitted the claim to the federal program. That's no longer the case. So subcontractors, vendors, whoever it is that violates the statute can be subject to enforcement. The Stark statute publishes exceptions. You're either in them or you're violating. The anti-kickback statute has safe harbor regulations that are just that. They say those things which, although they might tend to induce referrals, will be deemed not to violate the statute if you will comply with them explicitly. If you do not comply with a safe harbor explicitly, it does not mean that you violate the statute. It means that your situation will be evaluated with the dreaded terms of on a facts and circumstances basis using prosecutorial discretion. Those last two words you don't want to have ever present in your life, where you have to worry about prosecutorial discretion. The penalties, first of all, it's an intent-based statute. It's whoever knowingly and willfully engages in this behavior. And second of all, it's both criminal and civil. So you can go to jail for up to 5 years for violating the anti-kickback statute. That's not true for Stark. Transactions, again, that are non-compliant, where the dollars are not repaid, do convert to false claims, again, available for whistleblowers to act on. And there's a $50,000 civil money penalty for each violating transaction. So the dollars under anti-kickback, even before you get to the false claims exposure that exists, go up considerably in a settlement or enforcement situation.
So it sounds like you said, it's the sun and the moon and the stars issue. So give me an example of a situation where people think this is a Stark issue, but they're really it's really more of a anti-kickback issue. Are they just mostly misunderstanding because it's because of the type of people involved and they're...
Well, no, it can be that they think that it's a Stark issue when it's a service that's not on the designated hit list. So you're paying people for doing certificates of medical necessity for the performance of NCVs, nerve conduction studies. Nerve conduction studies are not a designated health service. So that's an anti-kickback problem. It's not a Stark problem. So if you're not on the designated hit list with the service that's at issue, it's not Stark. If the issue is that a drug or device manufacturer is paying inappropriate dollars for no-show jobs or things that amazingly continue even into 2022, that drug and device companies engage in, that's not the penalty that would be imposed on the company for engaging in that behavior has nothing to do with Stark. Stark is only physicians referring to entities for designated health services under Medicare where they have a financial relationship. It's far narrower than people think.
Apparently, which it's good to know, and it's good to have people like you who not only understand this but can explain it. What I'm thinking of, though, is a scenario where, let's say there is a clinical trial, and in the clinical trial, you've got a scenario where you've got one arm, which is a standard of care arm, and you've got the other arm, which is the experimental arm. And in those scenarios, as you know, the government is willing in certain cases to pay for the standard of care arm, but will not pay for the experimental arm. I guess I'm trying to figure out is, in those scenarios, how should one go about starting to analyze whether if you're talking about the standard of care arm, do you need to do a full-blown Stark and anti-kickback analysis to make sure that physicians aren't referring the work internally to their own entities, if you will? Is that a concern?
Let's start with a basic premise.
Okay.
That when you're engaged in clinical trials, the portion of the services that are considered medically necessary, you use the term standard of care. I use the term medically necessary, which is a precondition for everything that gets paid for by any payer and particularly the federal programs. But in the situation where there are a cadre of services that will be paid for by Medicare, the standard Medicare analysis has to be conducted. So the first thing you have to look at is there a service that falls in the designated hit list of the designated health services, otherwise referred to as DHS? What's the financial relationship between the drug or device company that's looking to have the doctors conduct the clinical trial? How are the dollars flowing? And then you have to filter it first through Stark. If you go through Stark, the basically three questions you have to ask yourself under Stark, and you come out scot-free, you're not done. Now you have to look at the Anti-Kickback Statute and say, do we have a safe harbor? Is it personal services, management services? What are we paying for?
I have a question, Alice. I'm sorry. Before you get to the anti-kickback piece, can we go back to the Stark piece? That you said there were three questions you have to ask. The first one was, is there a service? Is it a designated health service? Is the first question. Then the second question was, what is the relationship? What was the third question?
Is it a physician? Who's making the referral?
Okay, got it. Okay, so that's the third question. Who's the physician?
Yeah. Well, actually, you should start with if it's a physician. If it's not a physician, walk away.
Fair enough. So you don't need to go through that analysis with Stark at all.
As you go through each one of those, you get to say we're done.
Okay. So let's say you get past Stark. Your next, and let me ask you a question about what is the relationship. Could you explain what you mean by that? When you say what is the relationship, you mean is there co-ownership? Is that the question being asked?
Well, the physicians have financial relationships with all kinds of entities in all kinds of ways. So depending on who's paying for the clinical trial, they may have some additional relationship with that company.
Yeah.
And that's specifically in the clinical trials context. In the broader context, physicians have all kinds of relationships with entities that deliver designated health services. Most interestingly, another example of why the people who wrote this statute were morons, you'll forgive me for saying, they defined a referral. This is in the statute. It's not a regulation. They defined a referral as any request for a service, item, or good payable under Medicare Part B. Okay. So how are hospital inpatient services, home health agency services, how are they subject to referrals since they're paid for under Part A? So when the government had to write regulations, they wrote regulations that say, no, we're going to explain away this problem by saying these things really are covered under the statute, even though the definition is stated. I am not aware of any case that's actually gone to trial where this issue has been raised in defense, but there's a Supreme Court case that came down a couple of years ago called Escobar that said that for purposes of implied false claims, which means that you submit a claim, and the classic example that was the beginning of when implied false claims got created was a skilled nursing facility, Tucker House, here in Philadelphia, when Jim Sheehan was the chief of the civil division in the U.S. Attorney's Office, he very cleverly came up with a theory that when patients were showing up in hospital ERs with really terrible decubit eye bed sores, that instead of going in and saying this is a quality of care issue and having the surveyor survey the nursing home and make a corrective action plan and the nursing home complies, he came up with the theory that implied in the claim that was for each day of service paid to the skilled nursing facility for a patient being there was embedded the idea that they were feeding the patients effectively, and that the decubit eye, they learned from consulting with geriatricians at Penn, were exacerbated by malnourishment. So this theory of an implied false claim became wildly popular. Escobar was this case that came down, I think it's 2 years ago, that it would, with it's a very weird opinion when both sides claimed victory. But Escobar said that the government cannot rely on conditions that are not, the term they used was material to the payment of the claim, which has created this whole subspecialty now of trying to interpret what is implied in the claim, that and is it stated in a regulation, which the justices said you have to rely on something that's published in accordance with the Administrative Procedure Act, and not the thousands and thousands and thousands of pages of manuals, which are what operate the Medicare program on a day-to-day basis. So the implied false claims that are under Escobar are another area that gets implicated when these claims either under Stark or under anti-kickback get submitted. Now in Stark, the liabilities run predominantly to whoever is submitting the claim pursuant to the tainted transaction. Under anti-kickback, it's anybody on the food chain. It doesn't have to be the person submitting the claim. It's whoever's paying the inappropriate remuneration.
So
aren't you glad you asked?
I am glad I asked, because I feel like I'm learning so much. This is like a compressed health law course. So I appreciate it. And I think that the people listening, and hopefully some of the physicians who are listening in, are going to be like, yes, that makes sense, or oh my God, this makes no sense, and I need to reach out to Alice and ask her. But speaking of, you can always go to Alice's website at gosfield.com and ask her more questions.
We also have lots and lots of free publications that are on that website that elucidate a lot of the issues that we work on, including this nonsense.
Fair enough. So we did a very brief conversation about Stark, and we said, okay, this is Stark. Ask the 3 questions, and then kind of go from there. What happens, for example? I'm going to pick another example. Let's say you are a physician. You're doing research, obviously. As part of that, you're going to be testing on patients and doing standard of care and experimental arm, or medically necessary, as you said. Alternatively, let's say you were the inventor of a new device, for example, and you sold that device to this drug company, and now they're coming to you as the expert. So you invented this, you're now part owner of this pharmaceutical company, and now this pharmaceutical company is asking you to do this clinical trial. Does this, like, for me as a pharma health practitioner, I start going, I think is there a Stark issue because of all these interrelationships? Or do you kind of go, well, it all comes down to the actual services being offered by the physician, which is it a designated health service or not? And that's the only criterion. Or like, can you
Yes.
sort of?
So I actually wrote an article that you can find on the website that's about physician ownership and startup device companies, because it's not uncommon, particularly in orthopedics. We represent lots of guys who have contracts, and they get paid royalties when their patents. Yeah, when they're and that's fine. I mean, there has been a lot of anxiety. There's been a lot of myth and legend with regard to whether physicians can be in the ownership of startup device companies. The answer is they can. But when they are in the ownership of startup device companies, it complicates the way you have to analyze, not so much Stark, but on the anti-kickback side of the street, what's going on. They're allowed to get paid. They're allowed to get paid royalties, but the question becomes, can they get paid royalties on their own devices that they are prescribing for their own patients? That's a problem, because that could be seen potentially as a kickback. So you can carve out the personally referred services, and if it's commercially valid, in other words, that the company has enough business that it's not business that's being generated solely by the guy who invented this stuff, then you can go on. And another area that has been really wildly under review and investigation are physician-owned distributorships, and they are extremely problematic. I mean, I probably have not seen a single pod transaction that I have thought was legitimate. Not one of them. It's because the typical way they operate is that the device manufacturer offers to physicians the opportunity to invest in a sub company that has no validity. It doesn't do anything except provide the product to the hospital where the physician is operating and ordering his own services. So the pod thing, you can have a pod that's a true distributorship that's not related solely to the referrals of the people who own it. But most of the pod transactions were generated in the context of physicians who are the very physicians writing for the device when they're operating in the hospital.
Which brings us to anti-kickback at that moment then.
So, yes, it does. Good that you've been paying attention.
So do you want to talk a little bit about the anti-kickback law
well, again, it's exactly what I just described, which is that you have to look at whether the business is a standalone viable business. Interestingly, there is a small investment safe harbor under the Anti-Kickback Statute. It says that for any company that's not traded on one of the public stock exchanges, there's a separate exception, a safe harbor for that. But the small investment safe harbor, among other criteria, says that no more than 40% of the value of any class of shares may be held by those who refer or in a position to refer or do business with the entity in any way. A second 40% test under the small investment safe harbor, which has 4 or 5 other conditions associated with it, is no more than 40% of the revenues of the company may be generated by the owner. So I've had guys who have been invested, I had neurosurgeons many years ago that were invested in a CT scanner. There were 22 guys in the group. There were 8 guys that invested in the CT scanner. But the CT, so the whole ownership was tainted. All 40% of them were, no 40%, 100% of them were tainted. But because they actually put their CT scanner in a community where there was not so much availability of CT, way more than 40% of their business was generated by outside folks. So they weren't safe in the sense that they met both of those explicit criteria, but they didn't violate the statute because they were a standalone viable company. And one of the things that goes on in this sector of business is whether the lawyer you are communicating with is willing to write an opinion with a capital O. When I say an opinion, that is a special kind of letter that has magic words in it that say, therefore, it is my legal opinion that. There are major law firms in this country that will not write opinions under these 2 statutes. I do write opinions under these statutes.
Why won't they write these opinions? Because the liability is too high?
Yes. Now, I don't know whether they think the liability is too high here or because they're much broader law firms than us and they have securities liability, which is way worse than this kind of liability. They just take the position that they won't write opinions. All of my opinions specifically say may not be relied upon for the issuance of securities, because securities liability is a whole thing unto itself.
Fair enough.
But I just wrote an opinion yesterday that was on a compensation relationship where a dermatopathologist, and that's a Stark service, is married to a woman who's the owner of a dermatology group, and he was leaving his standalone dermatopathic business to become an employee in the group. So I wrote an employment contract for them. It has a compensation formula in it, and I had to write an opinion that said the whole transaction complied with Stark, and I was fine.
We can keep going on, as is obvious. We usually do this for about 20, 25 minutes, and we're well past that.
Well beyond that.
Here we are. Alice, this was amazing. So thank you so much for coming on. I hope you'll consider coming back on and explaining some more. Just before we go, how can people reach you again?
You can reach me at agosfield, one word, at gosfield.com, or go to www.gosfield.com. If you click on the read button, you'll see opportunity to click on publications. We have gazillions of them. Those are free. We also do teleconferences. Those are not free. So you can go to the listen button and romp around. There's a lot of stuff there. People like our website.
Awesome. Again, thank you so much for coming on. This was a pleasure.
Thank you for inviting me. I appreciate it.